Good afternoon, everybody. Welcome to another King's Bitesize seminar about injunctions, committals, and sentencing in the corporate protection. I'm delighted to have with us today on our panel Richard Borrett and Sophie Hurst, both members of the King's Corporate Protection team, and also delighted to have Sarah Jackson, who is a director of EMG Solicitors. It's bite-sized, so we don't intend to spend a huge amount of time today, about 30 minutes. Questions, if you have any, please do forward them along by way of email later on, and individually we can get back to you. The agenda for today is that we're going to consider a case of Macpherson, which Sarah is going to talk about in due course in terms of the facts, because that brings together all of the issues that I've just highlighted: injunctions, committals, and sentencing. I'm then going to talk about injunctions in the court of protection, when, what, and how. Contempt is then going to be spoken about in sentencing, and then that will be the end of the session. So I'm going to hand over, first of all, to Sarah. Sarah, thank you very much for coming along today. Sarah was instructed by the local authority at all levels, at first instance and in the Court of Appeal in Macpherson. So she is the perfect person to talk about an overview of that case. Sarah.
Yes, thanks, Sam. So I think the last time that we were here, we were in the position where the matter had been referred back to the Court of Protection for to determine LM's litigation capacity. And the court determined in that case that she had a capacity both in relation to the appeal and at the time of the committal. And so it went back to the Court of Appeal, which was heard on the 9th of September 2025. And the Court of Appeal framed the issues for them to consider in respect of this matter. Did LM act in contempt of court or contempt of the injunctions? Was the committal hearing fair, and was the sentence proportionate? And the court considered all of those points kind of in order. And the court held that LM knowingly and deliberately disobeyed clear injunctions and was therefore in contempt. Disagreeing with it didn't justify ignoring it. LM argued that it was the only way to get her views across was to publish this information about her daughter. However, the argument was not accepted, and the fact that the videos were pixelated and LM believed that no harm was caused was irrelevant. In relation to the next question of whether the committal hearing was fair, it was acknowledged that she was unrepresented at sentence. However, the court had considered whether to give an adjournment at that time, and the Court of Appeal found that there was nothing unfair about the process or any absence of safeguards or documents. And the court also accepted that the sentence was proportionate, and immediate custody was plainly right, and given the serious and repeated breaches, including whilst the sentence had been suspended, meant that a custodial sentence was appropriate. And I think it was important as well to note that persistent disobedience of court orders has to lead and attract custody, despite there being a reluctance of everybody involved to have to ask for that or to order that. So, yes, that was the outcome of the Court of Appeal hearing.
Okay, thank you, Sarah. And am I right in thinking that in terms of the injunctions in place, they related to stopping the individual recording and taking videos?
Yes, it was all about recording, publishing. It related back to kind of the transparency injunctions that we talk about, but also it went further than that. Because LM in the first instance had repeatedly recorded and published information on X and YouTube, and that's what had led to the breaches. And there'd been in the earlier hearings, there'd been a number of occasions where we'd got to court for a lot more breaches than what were actually found, and they were removed or taken away before we actually dealt with them. So the amount of breaches in terms of the injunctions that were actually dealt with by the court were actually a lot less than there were in reality.
So I'm just going to briefly go over the background of injunctions in the court of protection, when, what, and how. So in terms of when, as I've said there in my first slide, they tend to be, in my experience, very extreme situations when other methods haven't worked. And what I mean by other methods is going right to the bottom of that slide. is that if you are asking for injunctions, it's always good practice to identify whether you can achieve the outcome in another way, i.e. by way of best interest meetings and agreed outcomes, or alternatively, the best way to mitigate it is actually undertakings or promise to the court that an individual gives to act in a certain way. In those circumstances, I think the court will be quite reluctant to grant an injunction. But when those circumstances arise, are some of these. I've given you about 4 cases there, where different types of cases spanning a couple of years, where certainly in my experience they tend to arise. First, the first case I refer to is the health board case, where injunctive relief was granted for an assessment of P and the prevention of removal by a parent. So those types of cases are those where there's a lack of an assessment or a lack of detailed assessment of someone's capacity or best interests, and they're being prevented, or social services or the health board is being prevented from properly assessing. And so despite trying to deal with the situation on the ground, you need injunctions to actually complete the assessment. The TA case is quite an interesting one, quite a rare one. I don't think I've ever seen a similar case where an injunction was granted against the son of P, restraining him from communicating with the court office. Over a period of a year, he had sent 217 emails, made 39 top-line applications, and that was just in 1 year. I think the following year he made over 40. And the court took the view that there was a substantial risk that proper administration of justice would be impeded unless there was an injunction in place. I can see circumstances where that may apply to a local authority or an ICB or even professional bodies, which sometimes a lot of complaints are made. The third case is the case of SF, where which is probably the most common form of injunctions that certainly I've seen. Is injunctions would prevent someone attending on P's accommodation. So those would be in circumstances, for instance, where there was fact findings and adverse fact findings that say a family member or a parent had caused P harm, and it would not be in their best interest for them to know where P lived, and so in the absence of the injunction, that couldn't be achieved. So that's relatively common, as is contact regimes. So an injunction that there be contact, but only in accordance with the care plan. Sorry, the contact plan. Forgive me, rather than contact generally. And the final case is the REA case, where there's several citations there. I think there are 2 more, but those were wide-ranging injunctions made against a parent, specifically preventing her from making complaints to public bodies, making complaints to professional bodies, of which statutory body employees were related to, and injunctions in relation to contact, as similar in the SF case, but in relation to contact, and in that particular case, an unusual requirement to speak a certain language, because in that case, mother would speak to P in a language which was unknown to the carers, and there was evidence to suggest that they were she was destabilizing the package of care. So in terms of when, therefore, it can be quite wide-ranging. It tends to be, in my experience, for the completion of assessments, care, for the maintenance of a placement, or proper contact regimes, or certain behavior which causes distress to P. So as I say, before you get to that point, please consider other methods by way of best interest agreements or undertakings that can achieve the same outcomes. So in terms of then I'm not going to go into a huge amount of detail into the legal background, because it's relatively simple now and settled after this case of June 2022, where the Court of Appeal heard an appeal from the then Vice President, Mr. Justice Hayden, about injunctions on the family members, preventing them from sharing the story of P as part of the crowdfunding campaign, as I say in this slide. Essentially, the first point is that the power of the court is contained under Section 47(1). That confers the power of the High Court, and that power comes from Section 37 of the Senior Courts Act. So that's the general power that the court has to grant injunctions. And there's also a power under Section 16(5), which also allows the court to grant injunctions in circumstances to give effect to best interest decisions made pursuant to Section 16. It's worth, if you're interested, between the interplay of property and affairs and health and welfare, and in particular when the court refuses to grant injunctions, it might be worth having a look at the case of PG. There was a question mark as to whether P had a beneficial interest in the property, and a deputy district judge granted an injunction preventing a sale whilst that dispute was resolved. The senior judge of the Court of Protection, Her Honour Judge Hilda, set aside that order and said there was no justification because you can't protect someone's beneficial interest in a property by way of an injunction, because all injunctions must give effect to a best interest decision. So that's just worth having a look in terms of when a court won't grant an injunction. And then in terms of the test, the court will only grant an injunction to protect the interests of P, and there's this case of broad idea, which is referred to 2021 case in the judgment of the Court of Appeal. But essentially, when you break it down, that there's two requirements. First of all, that the interests of P must be that there needs to be a protection, and second of all, there's a justification for asking the court to prevent someone from doing something, and that culminates in what we call the just and convenient test. And in the case of G, Hayden J satisfied himself that P had an interest that merited protection, and that just and convenience test was made out. How? The Court of Protection rules, which is always the first starting point, provides for provision for granting interim injunctions. There's the Practice Direction 10B, which relates to urgent and interim applications. You must clearly set out what it is you're asking the respondent not to do, and provide some provision in the application for evidence. The general tips that I give overall are always about evidence. If you're asking for the court to grant an injunction, which is quite a draconian order that the court makes, it must be based on evidence. And so you must demonstrate, by way of a chronology, in my experience, the behavior that you're seeking to protect P against, and demonstrate that previous interactions with that individuals haven't worked. As I say, there is provision for making an emergency application in circumstances where, for instance, there's a potential that a person may take P out of the country. But then even when you're making those applications, please make sure that their evidence is there to demonstrate the emergency nature of it or the urgent nature of it. So say you've got all those steps in place. So we've talked about an example case of Macpherson. We've talked about the legal basis when those injunctions are made and how you make the injunction. When we now get to a point like the Macpherson case where the individual is held to be in contempt or potential contempt. So I'm going to hand over to Richard to talk about contempt.
Thanks. Yeah. So if in a case where there's an injunction, and the injunction hasn't, as you hope, had the effect that we want it to have, then the next step you have to take, the only next step you can take, is to issue proceedings for contempt of court. There's a number of procedural hurdles to overcome, and there's lots of ways that you can come a cropper in a contempt application, which I've seen myself on a number of occasions. But if we start firstly with just looking at what contempt is, there's actually an entire textbook on the subject of what contempt is, but there's also a very useful summary in the case of OPG and Salter. And I've pulled out some of the key points here, which very simply, contempt is disobedience of an order, or of course an undertaking in an appropriate case. It's very important that it is clear on the face of that order what it means and what exactly it prohibits. It's important to note that criminal proceedings are essentially criminal, even though they are in the Court of Protection or in the High Court. And I think that's the thing to remember throughout when you're thinking about procedure, both before hearings and in hearings, is to think that you are in a criminal court. And that will remind everybody of all the things that we need to do, the really important things like the right of the defendant not to answer any questions, and the burden of proof, which, as it says here, the burden of proof is always with the applicant, and it's a criminal standard burden of proof. The penultimate point here is contempt involves a deliberate disobedience of the order. Now, the interesting distinction here is that the act must be deliberate, but actually there's no need to show that the defendant intended to breach the order. So if the direction is not to contact P, you don't need to prove that they intended to breach the order. You only need to prove they intended to contact P and they knew of the order. Now, that it seems like a jump dancing on the head of a pin, but sometimes that subtle distinction can be important. And it's also, the point here is made that the judge must determine whether the defendant has done what he was required to do, and if not, whether it was within his power to do it. Now, that's in talking about injunctions to do something rather than not to do something. And it's fairly straightforward and kind of common sense point that a defendant can only do what they are able to do if they're directed to do something. What I haven't got into here is the issue of the contemner or the defendant's capacity. There's an interesting issue about what the test is for capacity in terms of understanding the injunction and therefore being in breach of it, and then the capacity to conduct the proceedings. Now, clearly, the test for capacity to conduct proceedings is Munster and Lister. We all know that. And that would probably be the same result in contempt as anywhere else. But there is some interesting authority, which is a little out of date now, which talks about the level of understanding required to be in contempt of a court order. And that authority says that the defendant only needs to understand in very simple terms, the court said, don't do X, and that the person did X. Now, there's an interesting argument to be had as to whether, following the Mental Capacity Act, that needs to be adjusted. So to be a full analysis of the defendant's ability to understand, retain, use and weigh and communicate their decision. It's difficult to know whether it would produce a different result. I had a case that came close to arguing this point, but we never got there because the capacity assessment said that the defendant had full capacity anyway. But a potentially interesting argument there. So having understood what capacity is, you need to then get the proceedings in place. The main places to look are Part 21, which has been updated a couple of years ago. That has a pretty comprehensive overview of everything you need to do. There's also a case of P and Griffith, which sets out a checklist of points, some of which are in Part 21, some of which aren't. And I've just said here, it's really important to make sure that you comply with everything, because I have seen a contempt application struck out for non-compliance. And in that case, it was, in fact, the only thing they'd done wrong, or two things had been done wrong, was the case wasn't listed properly. Although I'm not sure that was really the fault of the applicant, but also they'd applied on the wrong form, which I'll come to in a second. So I've set out here on the next slides a sort of summary of the key points, bearing in mind that it is fairly complicated, but just the sort of checklist of things you need to do. The application is done as a Part 10 application, so it's on a COP 9, not in the case that I was involved in, an M600, even though that may seem sensible because the M600 has all the relevant information on it. The evidence that you file with the application must be by affidavit. The application has to include, there's a list in 21.42 of specific information. I've summarized some of it there. But when you do the application, the grounds have to set out what the injunction was, what it said, exactly what the breach is that is said to have occurred. And you have to set out the defendant's rights and the risks that the court may proceed in absence, and that admission may reduce the punishment. The application has to be personally served unless the person already has a solicitor, although in most cases, even if the defendant is represented in the court proceedings, that solicitor may not be on record in relation to contempt proceedings. So that's something to be careful of. I always say just personally serve to be absolutely sure, because that's a very particular point where you can fall down quite easily. And actually it's quite easy to avoid falling down by just ensuring that you do personal surveys. So having put your application together, you come to a hearing. Some general points, these mostly come from P and Griffith, that the hearing must be a discrete hearing, although I have in a couple of cases seen judges not do that, and that is only guidance from P and Griffith, but normally it should be dealt with separately. The court should consider whether a different judge should hear, and obviously that's going to be more appropriate where we're looking at contempt in the face of the court than contempt in breach of court orders, but the court should at least give some thought to that. It's important that the defendant has time to prepare, which normally they will, because we're talking here about applications on paper and on notice. It's important to remember the defendant's right to silence and the right to cross-examine those who give evidence in relation to the contempt. Standard of proof is criminal. That's a very important one to remember. Ian Griffith says that the sentence must be done as a separate exercise, and the main reason for that is because the primary purpose of a contempt application is to ensure compliance. And so even if the defendant is found in breach, they should be given an opportunity to purge that by complying with the order. Finally, the court can proceed in absence. There's a test for that, which is in P and Griffith. I'm not going to get into that this afternoon. So the next bit is just some more specific points about the procedure at the hearing. This part is mostly from Part 21. The court does have the power to issue a bench warrant, and I have seen that done on a number of occasions. The effectiveness of that rather relies on how helpful the local police are going to be and whether you know where the defendant is. I have successfully used it in one case where we happened to know where the defendant was, and we had a very helpful police officer who happened to be at court who was able to arrange for them to be brought to court that very afternoon. Now, the court may sit in private. Fundamentally, as with all of these, all court of protection matters, open justice is a very important principle, even more so in contempt proceedings because of the risk of somebody being imprisoned. I put this here because the court can and sometimes does sit in private in contempt proceedings. Lincolnshire and X is a case I appeared in where the court sat in private for very specific reasons that I won't get into and are set out in the judgment. There are some very specific rules as to what the court must do. The press association have to be notified, and the court has to sit in public to give a judgment on why it decided to sit in private. But that is very much the exception to the rule. Reporting restrictions, important to note, transparency order doesn't apply, but the court does have the power to make a similar order. It's quite common to do that in relation to the identity of P, less common to do it in relation to the identity of the contemner, again, for the obvious reasons of open justice. If a contempt order is made, it must name the defendant, though. At that stage, there's no power not to name the defendant. And whatever else happens at the end of all of this, the court must sit in public and deliver a judgment, and it must be uploaded to the judiciary website. So that's a very quick overview of all of the things that you need to do to get your contempt application over the line and not get it struck out. And Sophie's going to take over now and tell us a bit about, if you've done that, what sort of sentence the court might apply.
Thank you, Richard. So moving on to the last point for this seminar today, which is about sentencing. So on the next slide here, I've set out where the power of the court comes from in terms of sentencing and the sort of orders the court can make when someone is found to be in contempt. And this includes, they can impose a period of imprisonment, they could do a fine, confiscation of assets, or other punishment permitted under the law. And so when deciding which of those sorts of orders to make, the court will look to apply a set of guidelines. And I think the most recent case really to deal with these, and the one that was certainly used in the Macpherson case, is the case of Re Dahlia Griffith. And I've highlighted two key paragraphs from this judgment. The first is paragraph 42, where the court essentially sets out what the function of a penalty for contempt is. And it says, firstly, it's, the purpose is to uphold the authority of the court by making the disapproval of the court clear and deterring others for engaging in similar conduct. And secondly, it's to ensure future compliance. And then moving on to paragraph 43, these are the principles that the court will apply, the court protection will apply when considering what particular order to make when contempt is found. So just running through these briefly, and they are all quite common sense, but firstly, the penalty chosen must be proportionate to the serious of contempt that the defendant has been found guilty of. Secondly, imprisonment's not the starting point. So as we've just seen, the court could order a fine, confiscation of assets. It doesn't automatically mean that imprisonment's the first port of call. But equally, moving on to point 3, there's no principle that a sentence can't be imposed. And so therefore, a prison sentence is something that is available to a court. The next point to raise, really, is that if the court does consider that an immediate term of imprisonment is appropriate, that term of imprisonment should really be as short as possible, having regard to the gravity of the contempt, and has to bear some relationship to the maximum sentence of 2 years of imprisonment that is available to the court. So obviously in cases where you have really serious breaches, you'd be looking towards the upper end of that 2 years. And in less serious cases where custody is still deemed appropriate, you'd be looking towards the lower end. The next thing to consider is if imprisonment is deemed appropriate, the court could consider and should consider whether in fact that sentence should be suspended or not. And having determined the length of imprisonment, the court should indeed expressly ask itself whether a sentence of imprisonment might be suspended. That's all very well and good in terms of principles, but I think the Macpherson case itself is a really nice case to look at when looking at how the court might apply those principles. So if the first time that Mr. Justice Paul considered the contempt and what sort of orders to make was in 2023, and this is where Ms. Macpherson had first breached some of the transparency orders and the injunctions that were in place. And in the first instance, Mr. Justice Paul said, well, look, there has been a contempt. I found contempt. It is serious because there's been a repeated breach by the defendant. And indeed, it's been sort of in flagrant opposition to the orders that I've made. She's been told that she needs to remove things. She hasn't done so. And so in this case, he said, actually, I do think a sentence of imprisonment is appropriate. But having regard to the circumstances, for example, in this case, Miss Macpherson's husband wasn't very well, and she was, I think, playing a key role as carer. Indeed, I think he was living in the home, so to confiscate the home as an asset wasn't going to work. But he sort of said, well, given she has flagrantly breached it, but this is the first time we're here dealing with a contempt of court, I'm going to suspend the sentence. So he suspended the sentence for 12 months. If we then move on to 2024, which is when the matter came back before the Court of Protection, on the next slide I've put the relevant paragraphs which deal with Mr. Justice Paul's decision. Actually, given that she's breached them again, and given that breach was in the period of the suspended sentence, he says we've now moved on to a point in time where in fact an immediate custodial sentence is appropriate. And he says, he emphasises in his judgment that, imposing a prison sentence isn't something that the court does lightly, and it doesn't particularly want to do. But there are circumstances where it is necessary and where it has to be done. And when the matter came back before the Court of Appeal for a consideration of whether that imposition of an immediate sentence of imprisonment was appropriate, the court was quite clear in its judgment, which I've set out on the next slide, that says, the sentence of immediate imprisonment was plainly right. And this was having regard to the serious and repeated flouting of the order. As I say, she'd already had a suspended sentence, and there was breaches of the order within that period of suspension. And the Court of Appeal was really clear that court orders are there to be obeyed. And whilst judges are reluctant to actually sentence someone to a period of imprisonment, it's important that those orders are upheld and obeyed. And yes, whilst judges are reluctant, this repeated breach will invariably lead to a custodial sentence. So when you're thinking about those principles as set out in the Dahlia case, I think the Macpherson case is a nice way of looking at how a court might actually apply them, bearing in mind how the breaches that Miss Macpherson the breaches that she made progress over the years and over the course of these proceedings. So I think that brings us just 1 minute over from the 30 minutes bite-sized seminar that we were hoping to deliver. So I hope that's been useful. As Sam said at the very beginning, if anyone has any questions, please do feel free to get in touch with us. I think we all operate an open door policy. We're very happy to receive questions and queries on any of the matters we've discussed today. And finally, I just think I'd like to thank everyone, especially Sarah, for joining us on the panel, and also everyone for taking the time to join us this afternoon. And we hope you found it very useful.